I have here with me two lawyers, members of Parliament, and I have Member of Parliament for South Dai in the studio, Roxanne Nelson Ache Dafeamekpor. Good morning to you.
Good morning, my brother.
And I have Andrew Ejapamesa, who is Member of Parliament for Secondary here.
Good morning.
Good morning, sir. How are you?
I'm well.
Over the last 12 hours, there's been this news about an Accra High Court setting aside a judgment by a juvenile court that jailed apparently a final year student of the Chimota Senior High School in Accra, and it's all for killing a female colleague back in 2017, in January of that year. We'll bring you the story. We want to apprise ourselves of that report, and then we'll have some short discussion on the subject.
Yes, sir.
We want them to establish the truth. She cannot be killed in that manner.
Just like that.
A mother in pain as she demanded justice. It was at a time when the accused was yet to be apprehended. Relatives thronged the family premises to sympathize with the family. 8 months later, a juvenile court presided over by Bernardine S.A. Senu handed a then 17-year-old a 3-year sentence for manslaughter. He was to serve the period in a correctional home. In November 2017, family of the convict headed to the High Court seeking to set aside the decision. They argued the juvenile court did not have jurisdiction to hear the matter as prosecution first commenced at the district court. They had also insisted the trial judge did not follow procedure in sentencing him before ordering for a social inquiry report to be issued. The state prosecutors had challenged these claims and urged the court to disregard them. Justice Kofi Dogu, delivering his judgment, held that the juvenile court judge erred in sentencing a student without first having access to the social inquiry report. It accordingly set aside that decision and directed a discharge of the student.
Mr. Dafeamekpor, let me start with you on this.
Yes.
I'm sure you may also have apprised yourself of some of the reports. I won't say the full facts of the case, though, but at least we all know what the media has reported.
Let me use the opportunity to say good morning to my constituents. It was a very big, busy weekend we had in Peki. Big funeral, Sunday, Thanksgiving service of the whole Peki state. So we had a busy weekend. Now, I was on my way to Accra yesterday night when I heard it over your channel on Joy 99.7 when they were recounting the issue. But being lawyers that we are, I aligned myself with the issues. Now, I think it's very instructive to know that the judge did not acquit and discharge. All right, at the High Court, even though it was an appeal, and it's quite interesting that you can, once an appeal comes before you, you are not overturning the decision of the lower court, but you are simply discharging the accused person. I want to believe the media didn't capture it well. Now, what will happen normally in matters like this, if it borders, this matter borders on procedural impropriety, pure and simple. First of all, because they charged the accused with manslaughter, they ought not, the arraignment ought to have been done simply at the district court. Then a bill of indictment would have been prepared. Then prosecution would have commenced at the High Court, not even at the Circuit Court. You understand? Because it's a charge of manslaughter, which, if convicted and sentenced, carries the maximum of a life. So I can understand technically where the judge is coming from. I have not read the judgment, but from what I gather, the judge ought to have overturned the decision, the conviction, the sentencing actually, and either refer the matter for trial de novo, that the matter ought to be tried afresh, because of procedural breaches, the trial as it happened before the district court is as though it never happened. So the appropriate things will be done. Now, the Attorney General, of course, defended the matter. They prosecuted the matter. And at appeal, they will be the respondents. And I'm sure they will be revising their notes. This is not a matter that they ought to appeal to the Court of Appeal, because it's purely on procedure. If they go further to the Court of Appeal, they may hit a brick wall. So they must come back and look at how they commence the prosecution. Did they follow the laid down procedure in matters such as this? When they did the arraignment, why didn't they prepare a bill of indictment and commence the trial at the High Court, but rather chose to arraign the person, indict the person, arraign the person before a district court, and ask a district court to trial a matter where the charge is one of manslaughter? It's unacceptable. It's unacceptable. So I hope they'll do the needful. The gentleman is not free. Nobody should make that mistake. He's only free temporarily because of procedural issues. The state can rearrange him, and so that the matter can be gone into on its merits according to the proper procedure as we know in our criminal jurisprudence. The other argument is that the High Court judge ought simply to have overturned the sentencing and upheld the conviction, because his issue was that he had been convicted on a charge of manslaughter. But prior to sentencing, it is mandatory that, because at the time he's a juvenile, I don't know whether he's turned 18 now, because we are told that he's 17 years. So at the time, he's a juvenile. A juvenile is a young person who is below 18 who has committed a crime. So he's not an accused person. He's a juvenile. At that age, you are a juvenile. That is why when you are sentenced, you are not sent to proper prison as we know it, but you are sent to a boster home, a correctional home. You understand my point? So he simply could have looked at the fact that, well, because you did not abide the submission of the social inquiry report before sentencing, you were wrong. And on that score, I am overturning the sentence so that they can remit the matter to the court, if it is proper to do so, for sentencing to be redone. But procedurally, a lot of the steps have been breached. So in my opinion, in my humble opinion, they should regroup, relook at the issues, and do the proper arraignment so that the issue can be determined on its merits in this matter.
Well, let me just say good morning.
But my sympathies to the victim's family. It is unimaginable for anybody to lose a child of this nature in such circumstances.
Good morning to you and my colleague here, of course, our cherished viewers, particularly my constituents in Second Day. Now I must admit my limited expertise in criminal procedures, because, as it were, I've basically done corporate practice. But, of course, there are basic fundamental principles that we all as lawyers are apprised with in law school. And I share the sentiments that have been largely expressed by my friend Roxanne here. Safe to say that it's always important in these matters to see the actual ruling, because media reportage may not necessarily paint the entire picture. And it's only when we see the ruling and the nuances that inform the judge in drawing, making the kinds of orders that he made, that is making the headlines today, can be properly understood. And so to that extent, I will limit my comments on that matter. Of course, I'm sure that in the course of the day, course of the week, we all may be able to lay our hands on the ruling to, as it were, understand what it is that went into it. But of course, it's important, as always, for the Attorney General, and I'm sure that in matters like this, they do not leave it lying at all. During your clip, I saw a gentleman, I believe is a family member of the lady, Asibeche. He was my mate in law school, and my sincere sympathy to the victim. And
so you saw the gentleman?
Yeah, I saw Mr. Asibeche in the clip, I didn't know that he was related in any way to this young,
in fact,
beautiful
the
lady.
girl is called Asibicha.
Yes.
Lily Jigbodi
Yes.
Asibicha.
Yes, yes, you know. And so I think we'll leave it there and then see what it is that will be contained in the judgment to enable us make informed commentary on it.
Anyway, so I wanted to ask, so now, if let's say they have to reopen, or maybe they have to go back to the drawing board and start, let's say ultimately, if the gentleman is, or if anybody of such nature was a juvenile when the crime was committed, or when the incident happened, and the person has passed 18, and the thing has dragged on for 3 years, so the person maybe is 19, 20. What happens?
It's a typical exams in criminal law.
Okay.
It's a typical exam they
Because
set
I've been
you.
wondering, it's something I've always been, I think this represented.
Any criminal law lecturer who normally will set exams around the things like this. It's a technical issue. But basically, what happens is that you cannot be considered as being of majority at the time you committed the offense. It's always the time of the commission of crime in issue that is in question. So indeed, the law reports are replete with issues like this. In fact, somebody committed a crime at 13. By the time the trial was over, he was about 25. You know, but his conviction was and sentencing was still done as if he were a juvenile at the time of the commission.
So what will he do? He'll go to an old person, an adult will go to the Boston home.
You see, it's at the time of the commission of the crime.
But I'm saying,
you speak to on Joy TV.
Well,
you do.
So what happens?
It's as simple as that. You can't send him to Insawam because of the duration of the trial. If convicted and sentenced is now at 10, 22 or 23, he must go to a prison meant for offenders and convicted felons who have attained majority. No. Yes. No.
Right. Now my mind is clear.
Yes.
All right. So let's move on. There's this issue about Martin Amido. We're told that after he's appeared before the committee will then go and regroup, take a decision, and they'll put together a report, and that report is brought to the plenary. Yes. Is that the procedure?
Indeed.
Okay. So what happens? What will be the procedure then?
Well, the committee as it is the Speaker's Committee.
Okay.
You know, so the committee as it sat is as if Parliament sat. It's only a subsect of Parliament. That is why they will tell you that we are facing a parliamentary probe or a parliamentary vetting, even though it's not the whole 275 who vetted you. So what happens is when it's done, they go into a conclave to consider the issues and prepare reports of how the vetting went. They touch on the very salient matters and then coming out with a recommendation. Now, at the committee level, members themselves will deliberate on each issue and agree or disagree. If those who disagree are in the minority, minority doesn't mean the minority caucus proportion on
just
the committee.
Numbers.
No, just
the numbers
individuals.
of agreeing or not.
Yes,
agreeing.
or not agreeing. So if those who disagree on a matter are overweighed by those who agree, you're overwhelmed, and so you give in. It's just it's a classical case of democracy. Majority will always rule. So at the end of the day, if that follows through the trend, then they can also agree either by a majority vote on the issues or on a consensus. Consensus is, hey, unanimity, or everybody is in agreement. Then the report will be brought to plenary. Plenary is the entire house. Indeed, those who participated, who are members of the committee, are sometimes given preference to debate. Sometimes to the speaker may vary the procedure and say, well, those who got the opportunity to participate in the committee will not be prioritized, and that members in the General Assembly will have the opportunity to debate. Now, when that is done, again, the question will be put to a vote. Those who are in favor will say yes. Those who are not in favor, they say nay. If the yes have it, we go. If the nays have it, then somebody may call for a divide or a division, as we call it. Now, division is you are not clear as to whether or not you have a clear majority saying no or clear majority saying no. So a division is, then it has to be a head count, you know. But I don't think it will get there.
Okay.
Yeah,
so which committee do you belong to in Parliament?
You know my committees. You always recite them here. Constitutional, Legal and Parliamentary, and Judiciary. We used to be together. Then they took him away from us.
So you belong to only one committee? Usually
no.
You belong
a minimum of two.
Yeah.
A minimum. There are some who belong to three, four committees.
So your other committee is?
Judiciary, the Judiciary Committee.
And then Constitutional and Legal. Yeah. Okay, so which committees do you belong to, sir?
Well, I'm now on the Communications Committee and the Privileges Committee.
Oh, great.
And a permanent friend of the Constitutional Legal and
I know, right? All right. So
you realize I was smiling throughout his presentation. You know what came to my mind?
At the committee level?
Yes, he gave what pertains at the committee level excellently. And that's indeed what transpires. But you recall the cash for seat. You realize he didn't mention that any minority report exists.
Oh,
so clearly the mischief.
Why?
Of the minority.
The procedure and convention allows anybody who has a minority opinion.
Oh, please.
If you are so minded to issue same,
he said that the committee members sit in conclave and decide on each issue.
Yes.
And each issue is put to a vote.
So you're saying he gave himself up?
Absolutely.
No.
So he's exposed the mischief that is not to play.
I have not.
No.
Ejapa.
That's exactly what you've done.
Ejapa. No, at all. If indeed anybody...
Did you participate in the voting on the issues at the Cash for Seed Committee?
Please. I am not a member.
That's all right.
If I'm a member, if I'm a member of the vetting committee, all right, appointments committee, and I decide that from the way things are going, I want to issue a minority opinion, I can issue it,
and it will come to Parliament as well.
Why not?
To the plenary as well.
Why not?
To the plenary as well.
It will be laid as a minority opinion on the matter.
The committee is supposed to present a committee report.
Okay, so now on
minority committee report.
But don't also forget that committee was a special committee. There are special rules that are
it's the same.
Mr. Mesa. So now we expect the committee's report before the plenary, but alongside there's a pending suit at the court. Okay, so if let's say another court, the issue is about age. And then also at the committee, if the nominee receives maybe a consideration or a confirmation, what happens then?
Well, the decision will be taken in Parliament today. We're going to go ahead, debate the report, and then take a decision on it. And of course, we'll await the outcome of the Supreme Court case. Because you recall that the plaintiffs themselves put as one of their remedies an order of the court to, as it were, set aside and declare null and void in the event that Parliament approves and goes ahead to as it were, endorse the nomination of His Excellency the President. So at that point, and only at that point, can, when the court makes an order that whatever it is that has been done is inconsistent with the Constitution, that orders can be made. Until then, the Parliament is not stopped from proceeding, and so that's exactly what's going to happen.
A small.
But you see,
okay,
the issue relating to age. Well, let me be cautious in not going into the matter. But I heard last week, in the heat of the discussions, that even appointing someone to a public service office after the age of 60 is in itself incorrect. But some of us argue that that cannot be the case, and there's a clear precedent. Appointments to the Supreme Court have been made of persons who were 69 years old. And it was legitimate, it was valid. So if the argument of the respondents in this case is that because the terms and conditions of the office of the special prosecutor is equivalent to that of the Court of Appeal judge. Of course, I know the decision of the court in the PC Appeal for case, and the facts therein are entirely different from what pertains in this case. So, conscious of that, if the court agrees with the argument of the respondent that 70 years is the retirement age, it cannot be the case that appointing someone who is 66 is incorrect, because AKP Kluje was appointed to the Supreme Court at age 69. He served for, I believe, 9 or 10 months and went on retirement the following year. Indeed, he was appointed on the 12th of May 2003 and retired in March of 2004.
And herein you're saying?
So the argument that appointing someone who has turned 60 plus offends the Constitution is incorrect.
Okay. So does it mean that if, let's say, we're saying that he can retire at 70, then it means that he can go serve for 4 years?
Absolutely, and go on retirement, and then the president at the time would exercise the same powers as provided in the law to appoint somebody else to occupy the office. It's not a big deal at all.
What's your own opinion on this?
My opinion is indeed at variance with this. You see, he's forgotten that under 1992, I should think so, Article 1992, it says that the retirement age is 60, unless otherwise provided in this Constitution. The unless otherwise provision, Roland, the unless otherwise provision is those in respect of the Court of Appeal judges and the Supreme Court judges.
Which says?
And the Electoral Commissioner and all
which
those
indicates?
Which indicates that they will retire at 70, unless otherwise provided. The unless otherwise provision are those that the Constitution internally within the same document says some people within the public service
give remits for.
Yes, can retire at 70. And we are being careful. So the question is the new creation, the office of the special prosecutor, contemplated to fall within that category of institutions? That's what we should be looking
and that's the question that the Supreme Court is ultimately be deciding. So I guess
but to
it's
say
important
that,
to leave it there.
But to say that his position is akin to that of a Court of Appeal judge, no. When we're contemplating the law, when we're framing it, when we're creating the office, did we contemplate that we will appoint somebody who will be above 60?
Did it always come to mind? Did it come to mind in the discussion?
Yes, we deliberated on these matters. But we're careful not to say that you must appoint somebody who is less than 60. We're careful. Because why? We even contemplated that a foreigner could become our special.
So in that case, if the contemplation was that you cannot appoint anybody above 60 into a public service office, does it include public service officers? Because judicial officers are public service officers.
That is why I'm saying the Constitution
and I've given you a precedent where an individual was in fact appointed to the Supreme Court at age 69.
And I am giving you the law in respect of that. The law in respect of that is that the Constitution itself says when you are appointed to the Supreme Court, or when you are a Supreme Court judge, you retire when you attain 70, not before, unless you do so voluntarily.
Yes, that is not in doubt.
Yes.
I thought that it was
and
the
I'm saying that
age.
No,
that
and I'm
you said
no, hold on.
That it cannot be.
Hold on. I am making a point. So where the Supreme Court is very clear that somebody can retire at 70, I as the sitting president, if I were, I am at liberty to appoint somebody who is 69. That is why the issue about Kluje's age was never in controversy. What people rather said was that the man was so much talented that he ought to have been appointed much earlier.
You mean knowledgeable?
Talented and knowledgeable in the law.
Talented?
Yes, and knowledgeable in the law. Have you read Kluje's work?
Well, I've read a number of his pieces.
Kluje was a lawyer's lawyer. You know,
well,
so,
I've heard that from lawyers too. So.
Yes, he was such he had a very fertile mind in the law. So we're crying that this man ought to have come much earlier. Why do you give him the opportunity to only do a year and go away? Those were the issues. So I am saying, to that extent, there's no problem. Here, it is silent. But the institution is eruditely described as a public office. Public office. And none more. So we'll leave it there. Let the courts reason. Let the courts give us a reason.
Public office.
Yes, a reason ruling on the matter.
Public office. When is the court expected to do that?
Oh, I'm sure these are procedural matters. When the defendants as respondents are serving them, it's an application indeed. So, but when they are served,
but Roland, it's important that when we finish the proceedings today, I'm positive that the report will be laid and debate carried out today will confirm clearly to all the doubting Thomases His Excellency the President's commitment to fighting this canker of corruption that has eaten into our fabric as a nation.
So now when we have headache in special office or special prosecutor.
And talking about that, you know that
accidents are happening in special office or special prosecutor.
You and I,
former President John Rawlings.
Yes, you and I went on this bill.
Yes.
In Koforidua.
Sleepless nights.
Absolutely. And we know the comments that we made there.
Yes.
In the committee consideration, clause by clause consideration.
I am not afraid to make them here.
Of course, we were all agreeable that we're creating a monster.
Indeed.
Which is going to come and fight the canker of corruption. We all agreed, both majority and minority, because the provisions and the powers that are given to the special prosecutor are enormous. For me, it is not even the prosecution of historical offenses that is of relevance to me. It is his power to investigate present officials. And you've heard some of our party people complain.
Who and who?
They are apprehensive.
Who and who?
I won't mention names. You listen.
Because I don't know about party people.
Well, some people have complained that the president is, as it were, taking his enemy in court and vesting so much power in that person. It tells me something, that this is a man who is really bent on fighting the corruption as he promised the people of Ghana. And so we should commend him for taking this bold initiative.
Well, he's been commended by former President John Rawlings. And he says that the appointment of Amidu as special prosecutor from outside his own party shows the president is serious. It vindicates some of us. So, that's right.
And anyway, I think that His Excellency the former president couldn't have said it any better.
No, I don't think so.
I'm only saying that they should let the institution be born. You should let it take off and give it time to function.
At this stage, there's no way it is going to suffer a stillbirth.
You understand? So the praise singing is becoming
too monotonous. Important. It's not a matter of praise singing. It's important that when people give a commitment,
you don't think
too monotonous. We all need to commend them.
You don't think that government also needs to make political capital out of it, because the decision that has been made.
So what has the Attorney General
premised on a party campaign?
So what has the Attorney General, her two deputies, Director of State Prosecution, Principal State Attorneys, Chief State Attorneys, Senior State Attorneys been doing?
They will be dealing with the other aspects of criminal proceedings and
what have civil litigation
on behalf of the Republic of
We
Ghana.
are all saying,
what are you talking about?
That we are saying is that this is supposed to be another institution that is supposed to make a prosecution of such cases more effective. More effective. That's all.
That's all.
That's all.
Nothing spectacular.
Already they are investigating a lot of cases concerning corruption-related matters. Do you understand me? Money laundering, all the contracts, procurement.
Money laundering is by FIC?
Yes, they're all coming. It's a form of corruption. They're all coming under. In fact, the law is that when the law matures and the office is set up, a lot of the cases from YOCO and FIC
will come to the office
will be offloaded.
Yeah.
Even from the AG's office will be offloaded to
the special prosecutors
for them to continue, or to take over and deal with.
Okay. There's a story
So we should allow the institution to
and commend the persons who created that institution.
So you should commend President Kufuor. Just
please,
do that and let's move
doesn't
on.
hurt to admit for once
the
that
commendation
this is
has
something
come,
good.
but it is becoming monotonous. That's my point.
Because you guys are refusing to commend as appropriate.
But we commend.
But that's fine.
But that's why I say you're happing on it too much.
Yeah,
You've become
I'm excited.
You've become King David.
No,
happing on
I'm
it.
extremely excited that, because look,
and the two of us, we are okay because we're private citizens. But you know that the law says you can also go after private citizens.
Of course. But as we speak, we are not private citizens anymore.
Indeed.
Yes.
So, okay, ECG bidding consortium rejects 51% local content policy, and the story is on page 3 of the paper on the Business and Financial Times front page. It's been captured as saying that French electricity conglomerate EDF, that's the French transnational company Veolia, and their local partner CH Group, who have put in a joint bid for the ECG concession. They've rejected the government policy that allocates 51% mandatory ownership of the concession to Ghanaian companies. And this was contained in a letter signed by one Kevin Datsi. And then in a letter addressed to the CEO of the Millennium Development Authority, and they said that, they expressed they said there were restrictions on the amendment under the protocols under which the whole concession is based, and they continue to say that it puts express restrictions on creating different categories or classes of shares in the new company. And so the requirement for this 51% threshold is to be maintained for the concession's full duration. And as a result, a potential company event of default will trigger the default buyout clause if this 51% threshold is not maintained. And according to the consortium, the above requires significantly impacts the consortium's ability to structure a workable solution. The consortium further stated that its financiers have cautioned that such restrictions will ultimately impact the concession's bankability. And they also said that as part of the security package, which will necessarily compromise any financing package, the 51% restriction is again problematic, severely restricting the enforcement rights of the lenders and negatively impacting on bankability of the concession as a whole. All right. And they're saying this is a suicide note for anyone or any consortium that wants to invest. Let me start with you, Mr. Mesa, on this.
Why is it? I understand that there are several consortiums or consortia that have.
Oh, I think now they've been restricted over 6. They used to be 25.
And those were the companies that had been shortlisted.
Yes.
And all 6 of them are complaining, or is only one of them who is complaining?
Well, one. If one is complaining, significant.
Really?
All we need is one to take the lead and the other will follow.
But you see, I mean, what really is the issue? One entity is seeking to put out an entity that he owns up for some concessionary arrangement for a certain number of years, and he's issued a request for proposals and has indicated the terms and conditions under which, if you are interested in participating in being selected to be the concessionaire, those conditions ought to be able to be met by your group of people. And that in that arrangement, it is seeking to, as it were, empower its citizens in having a controlling stake in the concessionary arrangement. And that consortium is writing to complain that empowering your citizens to take a controlling interest in whatever consortium arrangement is not exciting to me. So do what? Vary it so the foreigners can have a controlling stake? I don't think we should even be spending too much time on this matter. Because as far as I'm concerned, if all the entities that were putting up a bid were complaining that this arrangement is so onerous that they cannot meet under whatever international conditions or financial arrangements that they intend to undertake, and so they're making a representation to the Millennium Development Authority, which is working in tandem with the government of Ghana to implement this policy. Then it would probably require some conversation, because what that would mean is that we potentially may not be able to carry out the objective of handing over ECG to some concessionaire to manage and improve its operations over the concession period. But if it's only one party which is complaining that, well, your conditions are onerous for me and that I cannot go ahead to participate, I think they should just withdraw their or not submit their request for proposals for consideration. And I reading the story and listening to it on my way here, I was wondering what it is that they really want MEDA to do, that they should vary it such that foreigners can have more stake in the entity than Ghanaians. I don't think that. And I think that the government's decision to vary the conditions so that Ghanaians will have a controlling stake in the new company, the new ECG that is going to evolve, is something that is worthy of doing. Because under the old arrangement, I believe that the Ghanaian concessionaire was supposed to be about 20% or so, and that clearly meant that foreigners were going to control our energy distribution space. Of course, the whole objective is to introduce private sector participation in the management of ECG to make it more efficient and recover more of the losses that they make, so that they do not pass on the cost to you and I, the consumers. So if the decision now is that, look, rather than give 80% to foreigners, would rather give 51% to Ghanaians and 49% to foreigners, I think it's the way to go, and government should necessarily stick to it. People will be prepared to take it up if the conditions, under these existing conditions, and manage ECG for the benefit of all of us.
Mr. Dafeamekpor.
Yes, there are a lot of Ghanaians who have been trained at INSEAD in France, Yale Business School, Harvard Business School, Oxford Business School, Cambridge Business School, University of London Business School and all, Dartmouth, and some of them are available. Look, what is the value of ECG as we speak? I was in the district office yesterday, newly built, nice. They have all the logistics. Now, they have also built a new revenue collection point in Piki. It was inaugurated last month. What am I saying? The company is so strategic that I don't think we should even entertain foreign takeover. There are bright young Ghanaian business-minded and talented persons who can be recruited to restructure this company. Look, ECG ought to operate, the government ought to restructure ECG to run it on sectoral basis. We give power to ECG Western Region. We give you a certain amount of power, maybe 1,000 kVA. Sell it for 2 weeks and account. Volta, 800 kVA. Sell it for 2 weeks and account. If we don't disaggregate the aggregate of ECG, we'll run into problems.
And that's what we've been doing all this while.
Yes. Look, we've got into
you don't think if we have foreign participation or private sector participation will improve?
Why? We've seen what they've come to do with
Ghana Water.
No, Vodafone and Ghana Telecom. See how profitable it's become. You think we couldn't have asked Ghanaians to restructure it and run it? It's as if when the thing is being run by Ghanaians, then we are willing not to be efficient. But immediately we see foreign participation, the same workforce who sometimes are fortunate to be retained suddenly become efficient. They are time conscious, they are able to deliver reports and those things on timely basis. But when you see a fellow Ghanaian as the CEO or MD, oh, tomorrow funeral, the next day it is this, you see company vehicles doing all manner of things that are not related to the core mandate of the entity. Wait till you see an ECG senior staff dies. And you see the number of ECG vehicles all over this country that will come to the funeral. When perhaps that weekend there are breakages in lines along some areas that they ought to be monitoring and fixing. And you'll be surprised when these foreign partners come, all those activities and practices will cease. And our own friends and brothers will be willing to comply. Look, this is a government that is saying we are working to go beyond aid. Part of the aid is this. Should we be aided to run our own company? you understand my point? So
this is even better than the 20% that they came to meet.
Which 20%?
Oh, the concession, the initial one, for which we had extended public fora. They had
He's forgotten that this arrangement was
I have not forgotten.
You see, stop
the NDC MPP thing. I am speaking as an independent Ghanaian who is concerned,
talented Ghanaian.
Yes, who is concerned about again offering another strategic national asset.
But you introduce the element of this government.
He's not speaking on.
Why? If we introduce it and it's wrong, why can't you kick it out?
No, I mean the government.
I don't like Japan. You and I, we are.
You are above all.
We are above all this. When the thing is wrong, it's wrong. You are here complaining. Who says that? Who says that? Hold on. Who says that 51%?
You have signed an agreement.
Oh, please.
You are bound by the terms of those agreements.
Please. And you are reviewing it. You have power to review. And you are saying that.
Do you have a power to
you just said, Ejapa, you just said that you floated a request for
Please
proposal.
wrap up for me. Some nurses are picketing. I'm just
you
being told
floated a request for proposal and the RFP, you stated your terms.
Nurses are picketing.
So why is it necessary for us to fight? Who says that 51% is better than 20%?
It's not?
It is not. I just detest the fact that in this age, we are again going to give one of our strategic national organizations to a foreigner. When they cut your life, when they cut
you
the
remember
life,
Ghana Water? You know what we do.
I hear that we just so teshy. Now, when they cut water to Flagstaff House, what would they do?
Why? Is Flagstaff supplied by Teshi?
No, I speak of power supply.
Right.
So I am saying it's so strategic that we don't need foreigners to run this thing efficiently for us. We can reorganize it, recraft it, and let it operate and function in a way that we want.
But at the time that your
Andre Japamesa,
was going to sign this compact, it was your party that was in power.
Yes.
No, he's saying that we should move away from the party issue. We should be nationalistic.
Did we implement it?
But that is the implementation that is going on.
Oh, what implementation? You are still negotiating.
Negotiating what?
Are you not
the
negotiating?
Compact has been signed.
Have you not?
The compact
is supposed to give us the program.
Dafeamekpor is a member of parliament for South Dying. He just returned from the constituency yesterday. So he's up to date.
I'm happy that you signed to sell ECG.
No, we didn't
Andre Japamesa is a member of parliament for Sekendi. That'll be it for our discussions this morning.
I want to make another public appeal about the section of the road in Pong. Highway should fix the asphalt.
Which part?
Where the Ghana Water Office is. They excavated the road, fixed the pipe.
Yeah, they
have refused to lay the asphalt. And it's creating a lot of accidents when you are approaching Pong from Akosombo.
Yeah.
So highway should pay attention and ask Ghana Water to lay the asphalt at that section of the road that they excavated.
Yeah.